in Lithuania we have several forms of incorporation possible, and of course the most popular forms, like everywhere, are limited liability companies. There's two types of them, a public and private limited liability company. Other than limited liability companies, we also have partnership and individual enterprise as forms of legal entity. Also some other forms of legal entity used for various public purposes, like public institution, public organization, association, and so on. For businesses, we use limited liability companies because their liability is limited. The liability is limited by shares of shareholders. Shareholders are not liable for the company. The company is not liable for the shareholders. And since this is topical now, especially, piercing of corporate veil is difficult in Lithuania. There are very limited grounds, and corporate veil up till now has been protected strongly by Lithuanian courts. Basically, the only possibility of piercing the corporate veil and making shareholders liable for obligations of the limited liability company is by proving that there have been bad faith intentional actions of shareholders to by result of which the creditors have suffered losses. We have minimum capital requirements for private companies, 2.9 thousand euros. For public companies, about 44,000 euros. We have limitation of number of shareholders for private company at 249. Naturally, for public company, this limitation does not apply. The number of shareholders is unlimited. In Lithuania, companies must have the manager or the CEO. I know this is different in some other jurisdictions, but in Lithuania, the manager is mandatory body of the company. Also, all companies have general meeting of shareholders, of course. And then supervisory council and management board are optional bodies which could be chosen but are not mandatory. Directors on the management board are usually do not have independent power to bind the company, but they bind the company only by their decision as a management board. That's again maybe a peculiarity compared to some other jurisdictions. It's not so special, but there's different rules in other jurisdictions. And also we have the possibility of collective responsibility for the binding decisions, whereby if the bylaws allow, there could be 2 signatures required on any transaction, meaning that alongside the manager, a board member or a representative could be required to sign any transaction. This is sometimes used as a tool in partnership structures where there's 2 large shareholders and both of them want to be directly involved in day-to-day control of day-to-day activities. Auditing requirements, again, I think this is pretty common around Europe. There is auditing requirements for public companies, and with certain exceptions, it also applies to private companies. Permitting and licensing. Right now, actually, the Lithuanian government is engaged in the exercise of trying to reduce the number of permits and licenses that are required for businesses. They have actually tried to make a count, and it's really huge number that they arrived with of various permits and licenses that are required for businesses in various circumstances, and they are now trying to make a program to reduce those permits. I'm talking about all sorts of small things like fire safety, hygiene safety, this type of permitting. One of the kind of jokes, well, not fully jokes, but actually you need a permit to make child's clothes if those clothes do not have on them the light, that thing that reflects light. so that they are visible on the, and you need a formal procedure for that, which seems to be maybe possible to regulate by market. So permitting it depends largely on the, of course, area of activity. But on a large scale, of course, it's a free market. While there's room for perfection, generally there's no over-regulation or overwhelming control of the government over the private business by way of licensing. Main steps to establish a company, I would suggest you come to Targrunte Sutkiene. We can do that in 3 days for you. You can also go on the internet if you like the standard form articles of association, and that can also be done over the internet without, this is a recent development. But otherwise, of course, how we will do it, we will of course make the articles and the act of incorporation, and all of this is approved by notary public for its legality, and then registered with the Register of Legal Persons. The register is quite efficient. It officially does it in 3 business days. If it's very necessary, it can be done within 1 business day, but there's a special arrangement necessary. And the costs are, in essence, minimal, because they only include the bank fees for the account opening, the notary fees, and the register fees, and if you came to the lawyers, legal fees. But since it's a simple procedure, these are all quite simple and simple procedures and small amounts. One thing to remember is while it's very easy to incorporate a company, to liquidate is more difficult, and we'll come to that. But in essence, this is an important thing to remember, and this is why we do not. Well, it's good to kind of think in advance whether you will need to liquidate the company, because that is a more lengthy and costly procedure. You cannot liquidate it in 1 day. Even if it was incorporated in 1 day. Management, as we discussed, there's a need to have the manager. Companies may have management board and supervisory board. It's recommended for public companies traded on the stock exchange to have both of these collective bodies, supervisory board and the management board. The difference being that the management board is responsible for high-level decisions on day-to-day business activities of the company. Therefore, the members must be natural persons, since they also have fiduciary duties and liability for the consequences of their decisions for the business. While the members of supervisory council are more representatives of shareholders and are mainly engaged in supervising the activities of the other bodies of the company. And there you can have legal persons as members of supervisory board. The manager must be a natural person. There is no direct arrangement of management company, although legally it can be done by contractual arrangements, it's not foreseen in the statutes, but you can make the more or less effective structure. There must be an AGM in each company within the first 4 months of the year, and within 30 days after that, the company must submit their financial statements to the Register of Legal Persons. Liability, I think this is an important thing to have in mind. The manager and the board members will have liability for their decisions made in respect of the business. And in certain cases, if there is a bad management, there is a possibility for shareholders and creditors to claim liability from the manager or the board members. And of course, there is fiduciary duty on the members of the management bodies in the companies, and the requirement to avoid conflict of interest and to act in the interest of the company and all of its shareholders. It's again an important aspect which is actually overlooked sometimes, that members of the management board must act in the interests of all shareholders, not the shareholders that nominated them. Of course, it happens so, and this is only natural, that shareholders, especially in private companies, want the members of the management board to be their nominees and their representatives, but the members must be careful and must weigh their decisions, since of course they can have in mind the interests of the nominating shareholder in their decision making, but their decisions must not be directed at the interests of some shareholders and violating the interests of other shareholders, and that's important. This could result in liability of members of the management board. Acquisition, we have quite flexible legal structure regulating acquisition of companies. Of course, it's easiest and it's most used is the normal share acquisition. Of course, it's regulated if this is a public company and a listed public company. This is, of course, regulated by various securities market rules and by minority protection rules. But generally, of course, as a share acquisition is a legally simple and unregulated procedure. There's no transaction tax or similar restrictions on share circulation, and of course, with respect to public companies traded on the listed public companies, of course, the mandatory tender offer applies in case 1/3 or more of votes is acquired. And also squeeze out and sell out procedures are applied if 95% or more of votes are acquired. And there's also publicity requirements with respect to the transaction. This is again a very topical issue right now, but there's very new set of recommendations has gone out by the Securities Commission, whereby it is recommended for listed companies to alert the Securities Commission by at least the confidential notification of even the first steps in an M&A transaction, including hiring of the consultants to help with the transaction and conduct of due diligence procedures. So, of course, this is very new for the market. Nobody was used to doing that. It was taken for granted that this is a confidential procedure. Nobody should, and this is natural, of course, because there's no guarantee it will come to successful closing. But now, this is being looked into once again, a new kind of, and the confidential notifications are being made on transactions early on to the Securities Commission. In terms of other forms of transfer of business than just a share, just to finish about share transaction, most of the shares are non-material shares. They are recorded in shareholders' records, which are, in case of private companies, held by the company usually. Of course, in case of public companies, held by market intermediaries. The specific circumstances when there are material shares or share certificates, this is now quite an exceptional situation because it's not very convenient to have those, but if shareholders prefer to have those, they must be transferred by endorsement on the back side of the certificate, the good old-fashioned way of trading shares. And this is important because the transfer is invalid unless it is done according to the procedures that are set. Other forms of transfer of business, there is this transfer of enterprise. Gundars talked about it in Latvia. Everything is very similar, except we have the liability term instead of 5 years is 3 years in Lithuania after the transaction. And we have, I'm not sure if, at least I didn't catch when Gundars was talking about, but in case of transfer of business in Lithuania, the proceeds must be transferred to a deposit. The part of proceeds which should be enough to cover the creditor's claims, the immediate financial claims, must be transferred to a deposit from where the creditors could get their satisfaction. For this reason, and also for the reason that the civil code regulates that this transfer of enterprise transaction must be notarized, it is of course quite unpopular way. Although in some circumstances it is used and it's useful. Among other things, of course, we have various interesting structures of transfer of business. All that is in the book of M&A lawyers with various option structures and management buyout structures, leveraged buyout structures, also takeovers by various friendly and unfriendly actions. These are all made. These are not regulated directly by the law, but in practice these are happening. And basically, all of the transfer of business, I think the circulation is pretty common, and what you are likely used to in other jurisdictions, it's most likely that in Lithuania this is also possible. Of course, we have merger control. There, this applies if both the acquiring company and the company being acquired exceed 8.7 million euros in turnover in Lithuania, and each of them exceeds 1.5 million euros. So the threshold is lower than Gundars described in Latvia. For approval, it takes usually 3 weeks. If absolutely necessary, it has up till now been possible to get the so-called separate concentration steps approval. But the new chairman of the Competition Council is skeptical about this, so there could be changes in this one, and probably we'll have to live with the 3 weeks to get the full merger permit. Employment. I think by European standards, we have quite flexible regulation of employment relations, although probably by some other standards, the protection level of employees is quite high. We have limitation on concluding permanent or limited period employment contracts. There was an exception for the crisis, which is expiring next year. And the employment contract must be in writing. If there's a requirement that if a person is working a work which is considered to be employment without a contract, first the employer must formalize the relations by a contract in writing. Second, both of them face the danger of getting a fine of approximately 2.9 thousand euros for illegal employment. So this is being avoided, this non-formalized employment. The working hours, 8 hours, 40 hours a week. It is legal to have some overtime, but again, it is limited. Of course, the thing to mention, I think, like you can see in most of Eastern Europe, people are happy to work overtime without applying the overtime work tariffs and without applying the legal limitations normally. Of course, it depends again, and this is how employer can agree. But generally, the workforce tends to be flexible in terms of working time. Vacation, 4 weeks. Of course, we have up to 70 days of vacation for some professions, but that's peculiarities. And you can see that actually in the booklet on doing business in the Baltics. There's much more details. Minimum wage is about 230 euros. It's now being reconsidered. It will probably be increased shortly because there's a growth in the GDP, so the government will not be able to keep it so low for long. But of course, there's not going to be a dramatic increase. Termination of employment contract, this is not a very easy task. The termination must be either for cause or with quite significant compensation, which is progressively growing depending on the time that the employee has spent with the employer, working for the employer. If there is a termination for cause, or this type of termination without the causes described in the labor code, there must be at least 14 days notice. Again, and then there is a compensation which varies from 1 month's salary up to 6 months' salary if there's a termination for cause, and up to 18 and in some cases more salaries in case of termination without cause. There are protected groups. There's a strict protection against terminating a contract at the time of pregnancy or when the employee has a child of up to 3 years of age. There's basically very limited cases, even when when it would be possible to terminate for cause, and without cause it's not possible. Otherwise, there's limitations if there's a termination because of reduction of the workforce. There is a requirement to give priority to certain protected groups, like people who have less than 5 years remaining until the old age pension, and people raising alone kids up to 14 years old, and so on. What is important, these rules are important because after layoff, if the employee goes to court and the court decides that the layoff was not properly done, that it was illegal, the court would return the employee to work and would order the employer to pay salary for the full time of the dispute, which could be a couple of years. So that, and of course with all the taxes and social taxes to which we will come. So it's a serious decision, the laying off, and being careful about that. And all of these guarantees, they basically don't apply to the manager. This is a court case law, but the Supreme Court has, several years ago, has considered and made a decision that the manager is not an employee, is also an employee, but the main function is a managing body of the company, and the managing body can be changed by a decision of shareholders without applying the guarantees. Taxes. I think in Lithuania we have one of the lowest tax regimes, with the exception of workforce taxes in Europe. Since we're here in Estonia, Estonians will tell you they have even better. But this, I think it's also pretty good what we have. The general income tax is 15 for personal income tax. Dividend tax is 20. And some individual activity is 5%. Dividend tax paid outside of Lithuania is structured based on the bilateral double taxation treaties. In most cases, it's 10%. I think we have cases when it's 0. Dividend. There's an exemption, a group of companies exemption. So dividend tax is not paid if the dividend is paid out to the controlling company. But only the final shareholder gets to pay the dividend tax. Then corporate income tax is 15%. The company, just to follow up on the question that was raised with respect to Latvia, the company, after paying the corporate income tax of 15%, doesn't pay anything else. When paying out dividends, it's the shareholder's liability to pay the tax. Although in some cases, when the shareholder is a natural person and not a business person from tax point of view, the company could be responsible for calculating the tax and withholding the amount to be paid to the budget. Why I said that employment taxes are very high is the social tax. Social tax is quite high. The general rate is about 31–32% depending on case. And then there's health insurance contributions of 9%. It adds up to quite a significant number. VAT is 21%. Before crisis, we had 18 with significant exceptions. Now we have 21. I think it will stay like that for some time. There are still a limited number of exemptions. One is the books and various other services, medical products, and of course zero is applied for export. We have real property tax for commercial real property. We have no real property tax for residential property, but there is a serious discussion that residential property shall be taxed to some extent. There's a discussion whether the second residence shall be taxed or otherwise, but this is likely coming. And also land tax for owners of land, 1.5%. Owning property, taking security, I think just there's nothing really specific except for maybe several things. Agricultural land cannot be acquired by foreigners until 2012. That's an exception in our accession treaty. Otherwise, land can be acquired by foreign persons and companies with a limitation of their origin. It's called European and Transatlantic Integration Limitation, which basically means that anybody can acquire who is from a country which is a EU member state, European Economic Area member state, or NATO member state. Otherwise, it is not possible to acquire land for foreigners. We have an effective and transparent and quite quick real property registration system. All title and property rights are registered. This is all immediately visible on the internet, so you can check within seconds whether there is any encumbrance on the property. And the real property transactions are done by notaries public. It's a requirement to be notarized transaction, but it's again done by basically electronic means, except there is still a paper contract, but there's a program to abolish even that. All of the transaction would be only done by the notary in the notary's office and recorded directly to the real property register. Mortgage is also done by registration of a mortgage bond with the register, and it's public and easily visible. And of course, the most common security interest in real property is mortgage, since it's so convenient. Also, other security interests and other rights are possible, but these are already more sophisticated and more difficult. Like, for example, they're so sophisticated that sometimes you can be creative and there's a kind of ways around certain limitations. For example, there was a very famous story of using a property right called by Greek word emphitosis, which is the right to build on land. It was in a civil code. Nobody noticed it until one group of companies said that this was a proper right to have and build on municipality-owned land. Everything was perfectly legal, except that the municipality didn't really realize what they're doing until there was construction going on. But everything is legal. I mean, it's a good job for them to read the civil code attentively.
What did they build?
Well, they built some residential buildings. They built the sort of universal sports arena and aqua park and.
Can they get building permissions?
No, it's all legal. I mean, the only thing, and people in the municipality, the small people, they were happy with it because they read the book and this, yes, there is this right. But it was not, regulated as there's a large number of requirements for tenders and everything if you want to lease or if you want to buy the land. But there was none of these were applying to emphitosis, And so they. Actually, that was another right, superficies it was called. But anyway, that's the right to build on. And so on the political level, municipality suddenly woke up, and I think that was after the elections, because I think that one was, the mayor was happy. But it was really a case of, I think, also in a good sense, that people were creative and found that way. It was not, there's nothing bad done. The municipality got paid for it, and the only thing, there was no tender, but it was not required. So, concluding contracts, I think there probably there's nothing really much to say. We are a free market economy, and people are free to conclude any contracts they like, as long as this doesn't hurt the legitimate interests of other parties or is prohibited directly by law. What you must be careful about is that sometimes there's a specific form requirement, for example, notarization requirement. And failure to meet notarization requirement results in the contract being void. So that's, of course, a serious thing. Certain contracts have standard terms set forth in the civil code. So it's, of course, when the parties agree something, if there's a mandatory term set forth in the civil code, the parties will not be able to opt out of this. So it's good to read that book before signing the contract. Of course, consumer contracts are highly regulated, and the businesses are facing very high levels of regulation, high levels of limitations on what can and cannot be agreed with consumers. Governing law can be freely chosen, except that the mandatory rules and public policy rules of Lithuanian law will anyway apply if the business is happening in Lithuania. I think this is a common principle all over Europe. And dispute resolution, we also we have the freedom of choosing a dispute resolution body, except for very limited exceptions. We have, I would say, efficient and good arbitration. We have two arbitration institutions in Lithuania. One is kind of, I would say, maybe a lower level, second tier, and the other one is really first tier, is very good, and is very, he has, well, what it takes for an arbitration institution to be good is you need to have proper, transparent rules, which I think they just adapted the ICC rules, simplifying them. And then you need the institution secretariat not to do stupid things. So in that institution, it usually does nothing except then mailing papers back and forth, and otherwise it's in the parties' hands. The parties choose arbitrators themselves, and they. So arbitration is getting more popular for several reasons. One is the courts are very loaded. Two, and therefore it results in longer litigation. Although in the European context, I think litigation terms in Lithuania are quite short. I would say very short. If you compare. In Italy, nobody is surprised if the case is going for 5 to 10 years. In Lithuania, a normal case goes through three instances in about 2 years. But still, in arbitration, you can have your award within about 6 months. So people are opting for arbitration because of that, and also because of the quality of the work. Because since the courts are very loaded, they do not have the time to put the effort into really looking into details of things. And if it's a large transaction with complicated aspects, it's really difficult to decide in short time. And arbitrators, it will cost the parties, of course, but they will give the time and effort to go to the bottom, and therefore the popularity of arbitration is also growing. In terms of court system, we have three-tier system. We have the first instance is either local courts or regional courts. Second instance is for local courts, regional courts, for regional courts, Court of Appeals. And the supreme instance, which is only available in limited circumstances and only for disputes which concern interpretation of law, not interpretation of facts, is the Supreme Court. And we fully recognize foreign judgments, especially in the EU. It's regulated by European regulations, so it's very easy to recognize and enforce foreign judgments in Lithuania from the EU countries, but also from outside. Our Code of Civil Procedure basically abolishes the so-called reciprocity principle, which in international law means that Lithuania could legally refuse to enforce judgments of a foreign state which does not recognize the judgments of Lithuanian courts. So Lithuania said, we don't care. We will enforce any judgments, whatever the other state does with our judgments. So, and with arbitration awards, of course, they are enforceable under the New York Convention. And the Lithuanian Supreme Court is very pro-arbitration. In the 21 years of history of Lithuania after independence, there was only one case when a foreign arbitral award was refused recognition and enforcement. So the record, I think, is pretty good. Bankruptcy is actually not so efficient, not by reason of, there's a big debate now. I'm working in one working group on how to improve the system of bankruptcy, because nobody really fully understands why. But the bankruptcy cases, they tend to go long, and they tend to not recover the assets that could be recovered, especially if it comes to trying to annul transactions which were concluded before bankruptcy. The system is very inefficient. At best, it just takes what is left and distributes it to creditors, after subtracting the administration fees, which are high because of long proceedings.